Hey friends, consumer attorney Rob Nahum here. Today I wanted to talk a little bit about arbitration. I want to talk a little bit about what arbitration is and how you can use arbitration to your advantage. So particularly now during the Corona economy, we are leaning more and more heavily on the technology and these different companies that we rely on for services that we need on a daily basis. For example, our cell phone, right? Your cell phone service provider, we rely on them terribly. Your internet provider, you rely on them terribly. All these different consumer outlets that we go to for the goods and services we need, they all have contracts, right? They have terms of service or service agreements. Google has them, Facebook has them, Twitter has them, all the social media outlets have them, our computer manufacturers have them. They all have these agreements by which we agree in advance on what the terms of our use is going to be, right? That's all that big fine print that no one ever reads. Buried within that fine print is something called an arbitration provision, right? Basically what it says is that if you have a dispute with that company, you can't go to court to resolve that dispute. Instead, you have to go to this thing called arbitration. So what is arbitration? Arbitration is basically private court. You don't have a judge, you have some other lawyer that's getting paid as an in-between you and the corporation to resolve the dispute. It's supposed to be a scaled down process, right? You don't get encumbered by the rules of evidence and procedure that you have in a traditional court setting. This is sort of a let's get to the point kind of proceeding where you make your case, you present your evidence, and the arbitrator makes their decision. Let's be clear about this. Arbitration is a bad deal for consumers. The arbitration companies rely on the corporations for their bread and butter. This is how these private arbitration companies, this is how they exist, is these companies put in their contracts that you have to go to this private company to resolve your dispute, right? And this process has been blessed by every court that's ever looked at it. It's perfectly constitutional. It's perfectly within the realm of the law. So we're stuck. Our hands are tied. Every time we have a dispute, we have to go to arbitration. Now, why do the corporations love arbitration so much? The number one reason why corporations love arbitration, because it prevents class action lawsuits, right? If I have a dispute with my cell phone provider, maybe there's $300 at issue, right? That's not enough money really to justify someone going to court. It's certainly not enough money to justify a lawyer taking the dispute. However, if you can get everybody who's got a claim against Verizon for $300 and put them together in a class action, now that's powerful. And that's the kind of thing that these corporations are scared to death of, is consumers coming together as a group, as a class, to challenge some kind of business practice or product from these corporations. So what do? They hide it all in arbitration. It's this confidential, secret court with a private arbitrator. It's a bad deal for consumers. Now, having said that, it's the law. It's what we have. There are very few conditions and circumstances under which we can get out from under this arbitration. So this is the only game in town. How do we take advantage of it? What can we do in arbitration to make it advantageous to us? Okay, so the number one thing the corporations are scared to death of is that Congress is going to come along and say, you know what, these arbitrations are too penal against consumers, they're too unfair, it's too favorable for the corporations, so we're just going to ban arbitrations, or we're going to limit the applicability of arbitrations. Corporations are scared to death of that. So what they've done is they keep rewriting these arbitration provisions so that they appear to be less onerous on consumers. One of the real ways that arbitrations used to be a problem, and still to some extent are, is that who pays the arbitrator? Who pays the arbitration fees, right? Traditionally, the cost was borne by both parties. So the consumer, if the consumer wanted to bring an arbitration case, they had to be on board with paying upfront the arbitration filing fees, and then you have to pay the arbitrator's costs. Remember, the arbitrator is like a third-party lawyer. They get paid the same way other lawyers do. They get paid billing by the hour, or they get paid on a flat fee. What was going to happen here, back in the old days, was that the people, the consumer who got hurt by some company, had to agree to go to arbitration and then pay the arbitrator to have their claim resolved. So that started to be viewed by politicians and Congress and the committees that were looking into it and certain agencies, that practice started to be viewed as a little bit too abusive. So out of this desperation to protect this protection from class action lawsuits, what the corporation started doing is saying, okay, here's what we'll do. We'll pay the arbitration fees, right? And they put that in their arbitration agreements. We'll pay the arbitration fees. You just have to agree to go to arbitration and we'll agree to pay the fees. Okay, corporation, let's call your bluff. If you want to hide behind arbitration, if you want to avoid the light of day that you're going to get in a courthouse, exposing your business practice, I'm going to call your bluff and I'll take you to arbitration. I'll take you to arbitration because I know that you are going to have to pay the cost now. Your contract says it. Your contract says you'll pay the cost of arbitration. So if I have a $300 dispute with a company, or a $500 dispute or a $1,000 dispute, I'm going to go and call your bluff and I'll take you to arbitration. Now the incentives are lined up for the corporation to settle with you, to give you what you're asking for, right? Out of the gate, if you're going to have to file an arbitration, it's going to cost a couple of $100 right there. The company has to pay for it. Once the arbitrator gets assigned to the case, now the arbitrator's on the clock and the arbitrator's going to have to get paid for it. So now the bill really starts piling up for that company. Before a hearing in the arbitration even happens, the bill could already be a couple of $1,000s for this corporation. Now, if the corporation has to go and hire their own lawyer to represent them in the arbitration, the bill goes way up. The incentives are there very early on for the corporation to just give in, settle with you, so that you can be compensated for whatever it was the corporation did wrong in the first place. Let's be clear. Like I said, arbitration is a bad deal for corporations. It allows them to continue to get away with bad behavior. It allows them to continue to engage in abusive business practices, misleading business practices, because the light of day of court does not shine on what they're doing. It's hidden away in that arbitration, and because consumers can't gather together in a class action to call them out for it. Now, having said that, this is the only game in town. If you're stuck with an arbitration provision, take advantage of it. Bring them to arbitration and make them pay for what they've done wrong. Please take care of each other. Love and light.